wanted to talk about Senate Bill 4D, which was passed during the special legislative session, as you can see here. It largely relates to condominiums and cooperatives with buildings of 3 stories or higher. We'll talk a little bit about where that could apply to other cooperatives and condominiums, even that aren't 3 stories or higher. But let's go into it now. In terms of like the summary of what we're going to be talking about, there's a requirement to conduct what's called a milestone inspection. So this is all coming out of the basically, obviously, the Surfside collapse. And there was the regular legislative session, which did not have any type of new legislation passed. There was a lot of bills discussed. There were also bills discussed regarding construction defect, which I thought was an interesting time to bring that up, given the collapse of the tower and the need for more, I think stringent concerns regarding initial construction. And there was actually legislation that was aimed at reducing the time period for bringing claims. Thankfully, that wasn't passed, but we expect that could be put back on the table. But basically, what did come out of it in the special session, and Senate Bill 4D passed, which is effective as of May 26th of this year. So we're a little bit less than 2 months into it. There's a requirement for what's called an initial milestone inspection. It needs to be performed on a condominium or cooperative buildings of 3 stories or more in height, at least 25 years of age if it's within 3 miles of the coastline. There's a definition that they use for what is considered to be 3 miles of the coastline. It's pulling from a completely different statute for the definition, and we can provide that. But and if there is any question, if you're that close to it, I would reach out to legal counsel just to ensure whether or not, or just be on the more conservative side and plan on the 25 years rather than the 30 years. And it's for within 30 years of age for any other applicable communities. Then after that initial milestone inspection, you have to have a follow-up one every 10 years. So we'll go into it a little bit more as to what the detail is on all this. If the inspection is required in the building CO, which is a certificate of occupancy, was issued on or before July 1st of 92, then the milestone inspection must be completed before December 31st of 2024. The other note that we have is that a local enforcement agency may provide notice to an association that a milestone inspection is required, and if it's required, then must be completed within 180 days from the local enforcement agency. Once you have that milestone inspection done, if it identifies a substantial structural deterioration, then a phase 2 report is required. And the phase 2 report may involve destructive testing. If any of you have gone through construction defect litigation or any other type of substantial litigation regarding issues with construction or reconstruction projects, whether it's balcony replacements, resurfacing, whatever the case may be, or new roofs, that would involve destructive testing. Destructive testing basically is what you're doing is you're taking samples. It's not as bad as it actually sounds. Typically, the engineer will identify certain areas to cut into and look behind to see, is this a recurring issue? Is this a substantial issue that affects the rest of the buildings, so that they can determine what action may be warranted. So obviously, the phase 2 report's more involved because and that's only if the phase 1 report shows that, hey, there may be issues here that we need to investigate this further. A copy of the inspector prepared summary of the milestone report must be provided to every owner, regardless of the findings, and it has to be posted on the association website if you're required to maintain one. As a reminder, if you're a community, a condominium, or a cooperative of 150 units or more, then you're required to have a condominium website or cooperative website, and there are certain documents you have to maintain. So if you do have that, then you would have to post those findings to it. The other thing is that a local board of county commissioners may adopt an ordinance requiring commencement of recommended repairs within 365 days of receiving the milestone report. The Condo and the Co-op Acts were further amended to establish what are called structural integrity reserve studies as a defined term. The study must be performed by a qualified person, but the visual inspection must be by a Florida licensed engineer or architect. So as we're going through this, and I've talked to a lot of engineers and consultants that are qualified, we're going to be needing a lot more people in Florida in response to this and as a response to the requirements for what the statute provides in terms of having the structural integrity reserve study done, having the milestone inspections performed. I think what I heard was that there were 650 licensed engineers in the state of Florida. I might be wrong, and that might be completely wrong information that was provided, but it sounds right. And I think that if that is correct, we're going to need more engineers, licensed engineers that are qualified for this. And I think, unfortunately, what we're going to see happen is, because of the issues with Surfside and because of what's being required here, that they're going to be, I'm not going to say they're going to charge an extortionate amount, but it's going to be, there's some liability attached with these reports, of course, right? So I think I say all that not to scare everybody that this does affect, but just to understand where, if you are going to be fitting the criteria of needing one of these inspection reports done or having the study done, that you start planning for it now, both from a cost perspective and from a time perspective, because I think that we are going to have a lot of requests for this initially, and for a limited amount of qualified people that can actually do it. So even though you see here that for the initial structural integrity reserve study must be done by December 31st of 2024, or whenever the milestone inspection are done, depending on the age of your building, start planning for it right now. And we'll go into a lot more of the detail on this, but I wanted to provide the summary. A big key is that when you have the structural integrity reserve study done, this is a big thing that was discussed during the regular legislative session as well as in the special session, which is that you cannot use those reserve amounts for anything other than their intended purpose. And unlike any other type of reserve funds, you can't actually vote to waive or reduce the funding of the components as part of the structural integrity reserve study. That was a key thing that basically says that once you are required to reserve for those going forward, you cannot waive or reduce that funding, even if you take the membership vote. The importance of that, of course, is just to make sure that you're going to have that money available for the structural components that are part of the reserve study, and that, it's not being waived. We saw during especially the last housing downturn, I would say starting in 08 or 09, through those tough, 3-4 years or whatever the case may be, where we had a lot of delinquent owners in payment of assessments, that we had a lot of associations reduce their reserve funding, which you're allowed to do as long as you take the member vote. And I actually represented some associations that completely waived their reserve funding, which kept their assessments lower. But obviously, whenever you have, a big project, whether it's a structural project or anything else, or roof replacement or repainting, if you don't have those monies available, it's going to be tough on owners. You're going to have to specially assess for it. The legislature didn't even want to leave that to chance for structural components. I think it's, again, to make sure that the money is available when it's needed. A key thing here is you see here on the last sentence on this page that the failure to complete the study is a breach of an officer's and director's fiduciary relationship to the unit owners. A copy of the study must be maintained for 15 years. An updated study must be performed every 10 years. So this is an amendment essentially to the official records requirements. So again, there's placing an importance on getting this study done and actually placing pretty strict. I mean, it specifically states here that the failure to complete it is a breach of the fiduciary relationship to the unit owners. If you've attended any of my courses before, when I talk to new board members about, what your obligation is to the members, what duty you are required to, that you afford by common law, it's a fiduciary relationship, but it's not spelled out to this effect that the failure to do so is considered a breach of it. So it places a big burden on you as the board members. If you're, most of you are probably board members attending or managers, that the failure to do so is a breach. So obviously need to take this seriously. I know everybody will, especially, that this applies to. Another thing is that all condominium and cooperative associations existing on July 1st of 2022 must, on or before January of 2023, report to the Division of Condominiums, Timeshares, and Mobile Homes, the number of buildings on the property that are 3 stories or higher in height, the number of units in all such buildings, and the addresses of all such buildings and the county of which they are located. So we haven't been provided yet that they have the reporting up. That might have changed somewhat recently in the last week or so, but I'm not aware of it. They will be providing that so that you can report, because as you can tell here, the fact that they're asking for it is that there isn't a great way. They don't have a great database as of right now to determine, okay, out of our X number of condominiums and cooperatives in the state, how many of those actually are subject to the new laws in place, the 3 stories in height or greater. So that will be put out. This is kind of similar to, I would say, a couple of years ago, where for homeowners associations were required to actually just report to the state that they lived in an HOA and how many homes were part of it. I think that was beginning of the data gathering stage there for more oversight for HOAs. This is more specific as to the 3-story and height condominiums, but again, this is going to have to be reported by January 1st of next year. Once that goes live on the DBPR website, if it hasn't already, which if it is, it would be more recent, should be fairly simple to upload it, but that will be a requirement. Doesn't say specifically what the penalty is if you fail to do so. But I know that Vesta will make that information available to everyone. All right, so I'm going to go into that's kind of an overview of the changes that came into effect as part of the special session. And I know this is largely geared towards condominiums and cooperatives, and especially those with 3 stories or higher in height. And again, looking towards the larger condominiums, and again, everything's kind of flowing from the collapse at Surfside. So larger condominiums that might have structural issues that want to get out in front of it in terms of some of these requirements for it. So I'll go into some more of the detail here. There was a change regarding to Chapter 553 regarding windstorm loss mitigation and requirements for roofs and opening protection. This states that if a roof system or section was built in compliance with the 2007 building code or any subsequent additions, and 25% or more of the roofing system or the roof section is being repaired, replaced, or recovered, only the repaired, replaced, or recovered portion is required to be constructed in accordance with the building code in effect. So basically, if you're having to repair a certain section, that's the only part that needs to be brought up to code in effect at the time, not the entire system having to be replaced. Okay, so that's one changes to 553 on the insurance side. For 468 regarding CAMs and management companies, says that if a community association manager or management company has a contract with a community association that has a building on the association's property that's subject to 553-899, which that's the 3-story or higher in height, the CAM or the management company must comply with 553-899 as directed by the board. So again, placing more responsibilities on management. They're kind of tying in management and then the obligations for the board to make sure that everything's carried out as required for any type of the mandatory structural inspections and the reserve studies. 553-899 is created that addresses the mandatory structural inspections for condominium and cooperative buildings. So this is the milestone inspection. It's defined there. It means a structural inspection of a building, including load-bearing walls and the primary structural members and primary structural systems, as those terms are defined. You can go look at 627, by a Florida licensed architect or engineer for the purpose of attesting to the life safety and adequacy of the structural components of the building, and to the extent reasonably possible, determining the general structural condition of the building as it affects the safety of each building, and then a determination of the necessary maintenance, repair, or replacement of any structural component of the building. So the purpose of the inspection is not to determine if the building is in compliance with the Florida Building Code or the Fire Safety Code. Primary structural member is defined as a structural element designed to provide support and stability for the vertical or lateral loads of the overall structure. And the primary system means the assemblage of primary structural members. So again, kind of terms relating to each other here. So this talks about 553-899, provides that the milestone inspection consists of 2 phases. The first one, which is what we talked about, is that a licensed architect or engineer must perform a visual examination of the habitable and non-habitable areas of a building, including the major structural components of a building, and provide a qualitative assessment of the conditions of the building. If the architect or engineer finds no signs of substantial structural deterioration to any building under visual examination, then the phase 2 inspection is not required. So it could stop right there after you do the phase 1 report. You do still have to complete the phase 1 milestone inspection and must submit an inspection report, which is defined under 553-899. So a lot of this is going to be applied, to the engineers and the architects, that they're going to have to follow the statute to understand what they're required to submit. But it also falls on the association through the board and the management company to make sure that they are providing to us what's required, so that we then have it and we can show that we comply with it, and then provide a copy to the members under the statute. So the phase 1 report talks about, again, the visual examination, and that's kind of the first stop to see whether or not there's an issue. If there is an issue potentially, then the phase 2 milestone inspection must be performed. It may involve destructive or non-destructive testing at the inspector's direction. The inspection may be as extensive or as limited as necessary to fully assess areas of structural distress in order to confirm that the building is structurally sound and safe for its intended use, and to recommend a program for fully assessing and repairing distressed and damaged portions of the building. Then it says that when determining testing locations, the inspector must give preference to locations that are the least disruptive and most easily repairable, while still being representative of the structure. And that's common for any type of destructive testing. It's basically saying that you don't need to cut into under every single window, under every portion of a wall. The engineer can look at it and say, I'm going to cut in these specific areas to look, because that's a representative sample of the buildings. And that's common for any type of destructive testing, not just specifically related to this. An inspector who completes a phase 2 milestone inspection must prepare and submit an inspection report per 553-8998. And that's a report, again, more specifically defined, and you can find a little more of the detail there under the statute. 553-8993, it requires that a condominium associations under 718 and cooperatives to have the milestone inspection performed for each building that is 3 stories or more in height by December 31st of the year in which the building reaches 30 years of age, based on the certificate of occupancy was issued, and every 10 years thereafter. However, as we said before, if the building is located within 3 miles of a coastline, and here's the statutory reference, it's 376-031. Actually, let me see, I should be able to pull that up and show you real quick here. I can actually pull that up for you so you can see. And if anybody needs to, you can look this up as well. 376-031. Let's see, and you should be able to see this. Coastline, 3 miles of coastline, and coastline is number 4 here, means the line of mean low water along the portion of the coast that is in direct contact with the open sea, and the line marking the seaward limit of inland waters. Okay, so that's the definition of coastline. So if you're within 3 miles of that, again, if you're that close to it, I would err on the side of treating it as within 3 miles, just to not run afoul of the 25-year versus the 30-year requirement. But that is the definition that they use. And again, once the inspection's done, you have to perform it then every 10 years thereafter. Associations obligated to arrange for the inspections, responsible for compliance. Associations responsible for all costs associated with the inspection. It doesn't apply to single family, 2-family, or 3-family dwellings within a 3 or fewer habitable stories above ground. So that's for like the very, very small condominiums. If you're in here, even if you're like a 3-story, if it's a 3-family dwelling or less, you wouldn't be subject to this. Probably not many of you, if any of you are in here that would have that exception, but that would be the one exception to the 3-story or higher requirement. Next part is that if the building certificate of occupancy was issued on or before July 1st of 92, so obviously that would put us already past 30 years, then the building's milestone inspection must be performed before December 31st of 2024. So they're basically saying that if you're already reached the the 25 or the 30-year marker because your CO was issued prior to July 1st of 1992, then you've got a couple years to arrange for this, right? It's not like you have to go out and you're already past due or anything like that. That's why I do say, though, that you want to start arranging for this immediately, because I think that as you get closer to that deadline, all of the qualified engineers and architects that would be able to perform that are going to be booked. They're going to be busy. So you want to make sure, and it's not just the time for the inspection, but also then, the report that comes after that. So again, December 31st of 2024 is really the deadline for when the milestone inspection has to be done. One thing that's going to be interesting to see is upon determining that a building must have a milestone inspection, the local enforcement agency must provide written notice of such required inspection to the association by certified mail. So the local enforcement agencies may be reaching out. They may be already staying on top of this and saying, hey, you're required to have this done. They can send that out certified. So I'd be starting to look for that. Within 180 days after receiving the written notice from the local enforcement agency, the association must complete phase 1 of the milestone inspection. So it's going to be interesting to see how that affects versus the what the time period is that's provided in the statute. I think we're going to see some cleanup from this in the next legislative session to make sure that associations aren't unreasonably impaired, I think, by a local enforcement agency versus the dates that are provided in the statute. And there may be some back and forth as to interpretation with the local enforcement agency too. Completion of the phase 1 inspection means the licensed engineer or architect who performed the phase 1 inspection submitted the inspection report by email, by US mail or commercial delivery service to the local enforcement agency as part of the compliance with the 180-day requirement under that part. All right, so 553-8992B, it defines what substantial structural deterioration means. So this is what the key part is of whether or not the phase 2 report is required and what's going to be included in that report. Substantial structural distress that negatively affects a building's general structural condition and integrity. It does not include surface imperfections such as cracks, distortion, sagging, deflections, misalignment, signs of leakage, or peeling of finishes unless the licensed engineer or architect performing the phase 1 or 2 inspection determines that such imperfections are a sign of substantial structural deterioration. So I think that's going to be the key thing, is substantial versus non-substantial, and whether or not that's routine maintenance issue, the stuff that comes up, versus no, this is a sign of bigger structural deterioration. I would be prepared for, engineers and architects to take a more conservative approach. Just think about it from their viewpoint, right? What if an engineer or architect, labels something that that they don't define as substantial and actually is a substantial issue that leads to a problem with the building and God forbid, some type of a subsequent tragedy again, the liability for engineers and architects would be through the roof. So I think that they're going to be taking a more conservative viewpoint, fortunately or unfortunately, the way you want to look at it, right? Unfortunately, from the standpoint of, if they're overly conservative, that may obviously result in additional costs that may not be totally necessary, depending on, what substantial work is done. But, fortunately, because you'd maybe rather err on the side of caution when you're talking about, honestly, structural integrity and human life. I mean, if we're talking about, I would rather err on the side of being more conservative with it. So I think it's going to be interesting to see what comes out of it. But I was just cautioning associations that we're working with to prepare for a more conservative viewpoint, which means more likely to define and highlight areas that are going to need, work and repairs done. 553-899 provides that upon completion of the phase 1 or 2 milestone inspection, the architect or engineer who performed the inspection must submit a sealed copy of the inspection report with a separate summary of, at a minimum, the material findings and recommendations in the inspection report to the association and to the building official of the local government which has jurisdiction. The inspection report must, at a minimum, bear the seal of the or electronic signature of the architect or engineer, indicate the manner and type of inspection forming the basis for the inspection report, identify any substantial structural deterioration within a reasonable professional probability based upon the scope of the inspection. And then you have to describe the extent of such deterioration and identify any recommended repairs for such deterioration. And then state whether unsafe or dangerous conditions as those terms are defined in the Florida Building Code were observed. So, and I have here the definition for what is a dangerous condition under the Florida Building Code. Under the 2020 version, dangerous is defined as any building, structure, or portion thereof that meets any of the conditions described below shall be deemed dangerous is if the building or the structure has collapsed, has partially collapsed, or has moved off its foundation or lacks the necessary support of the ground. There exists a significant risk of collapse, detachment, or dislodgement of any portion, member, appurtenance, or ornamentation of the building or structure under service loads. And then unsafe is also defined here Building structures or equipment that are unsanitary, that are deficient due to inadequate means of egress facilities, inadequate light and ventilation, or that constitute a fire hazard, or in which the structure or individual structure members meet the definition of dangerous. So obviously, that's probably the part that we're more concerned with here as part of the milestone inspection, is it's unsafe if it meets the definition of dangerous or are otherwise dangerous to human life or the public welfare. So all coming into, and this is where the engineer, the licensed architect, is going to have to apply these definitions as part of their report. The report's also going to have to recommend any remedial or preventative repair for any items that are damaged but are not substantial structural deteriorations, and identify and describe any items requiring further inspection. And we have a note here, the exact scope of what is required to be included in the separate summary, which is really for any items requiring further inspection, is not clear yet. Again, talking about, like, this is from the special session, and there's already been discussion of a cleanup bill for next year on this that will help further clarify some of this stuff. 553-8999 provides that the association must distribute a copy of the inspector prepared summary of the report to each owner, regardless of the findings or recommendations, by mail or personal delivery and by electronic transmission to those who consented to receive. And this is how the statute reads, a little bit typo there, notice by electronic transmission. And you have to post a copy of the summary in a conspicuous place on the condominium or cooperative property, and must publish the full report and inspector prepared summary on the association's website. So again, full disclosure for all this, mailing it out or emailing it out to people that received or that provided consent for electronic transmission, posting on the property and on the website if you're required to have a website. So full disclosure and information being provided to all the members. Local enforcement agency may prescribe timelines and penalties with respect to compliance with it. So that will be interesting to see what each local municipality may come out with. Talked before, but the Board of County Commissioners may adopt an ordinance requiring that a condominium or cooperative schedule or commence repairs for substantial structural deterioration within a specified time frame after the local enforcement agency receives the phase 2 report. But it says, however, such repairs must be commenced within 365 days after receiving such a report. So I think a big thing for everybody to note from this is that not only are we now having these first milestone inspection reports, but if it identifies issues, then a local enforcement agency may require then not only, obviously you've identified it, but then that the work needs to be done. And so I think that's why we have, and we're going to talk again in more detail on the reserve side to make sure that money is available. But if you're in a building that identifies issues right now, a local, after receiving that report, and once that's done, there may be within a year of the amount of time that you have to actually perform the work. Now, I think that could be potentially, it would be interesting to see what comes out of it with associations, that because I think we're going to have an issue with the number of engineers or architects that can oversee such work and prepare the scope for it, and obviously qualified contractors that you can work with. So we'll see in terms of how hard and fast that 365 days is, but I think you should be notified and cognizant of the fact that the local enforcement agency can come in and say, hey, we've seen this phase 2 inspection report. It looks like you have some substantial issues. You need to commence those repairs within 365 days of the date that the notice is provided to you. So be mindful of that, not only for getting this done, but also if you have concerns right now, even I would say that there might be structural concerns with your buildings, or err on the side of caution, add that to your already existing reserve summary if you don't already have that. I wouldn't say it's common. Not many associations have structural components as part of their reserve, funding. It's typically your standard ones that are required, which are the roof replacement, the pavement, the painting, anything over 10,000. But I think a lot of associations are going to start looking, even if you don't have all of the specific type of studies done and the reports done, that if you're in an older 3-story or higher structure, to maybe start looking just so that you can ease into the funding a little bit, rather than kicking it in a couple of years from now and having to have a higher funding amount. All right. See, 553-899 provides that the Florida Building Commission must review the milestone inspection requirements and make recommendations to the legislature to ensure that inspections are sufficient to determine the structural integrity of a building. The commission must provide a written report of any recommendations to the governor, the president of the Senate, and the speaker of the House by December 31st of 2022. So if that's done and there's anything else that may come out of this that may modify or anything on the inspection requirements, then we'll probably see that come out of based on whatever reports provided by the Florida Building Commission. The other requirement is that the Florida Building Commission consults with the state fire marshal to provide recommendations to the legislature for the adoption of comprehensive structural and life safety standards for maintaining and inspecting all types of buildings and structures in Florida that are 3 stories or more in height. Again, must provide a report of recommendations by December 31st, and this is of 2023. All right, so let's jump into then some of the amendments specifically. And again, I talked about this in summary, but going into a little bit more of the detail for 718 and 719. And I'm only really addressing 718 here, but the definitions for cooperatives of 3 stories or higher are substantially similar to it. So you can apply these for both 718 and 719. So 718-103-25, that's a new addition, which defines a structural integrity reserve study. It means a study of the reserve funds required for future major repairs and replacement of the common areas based on a visual inspection of the common areas. Structural integrity reserve study may be performed by any person qualified to perform a study. So you would still use your reserve analyst that you've used before, but the visual inspection portion of the structural integrity reserve study must be performed by an engineer licensed under Chapter 471 or an architect licensed under 481. So a Florida licensed engineer architect basically needs to work with the typical reserve analyst. And I know when a lot of this was coming out, or even before we had the special session, a lot of reserve analysts were saying, look, I'm not an engineer. You know, if there's going to be a requirement for this, it's going to go beyond the scope of what I'm licensed to perform. And I think that's acknowledged here by the fact that while you can still use a qualified reserve analyst, you would need to use an architect or an engineer for the visual inspection for the structural components there. It says at a minimum, the structural integrity reserve study must identify the common areas being visually inspected, the estimated remaining useful life, and the estimated replacement cost or deferred maintenance expense of the common areas being visually inspected, and provide a recommended annual reserve amount that achieves the estimated replacement cost or deferred maintenance expense of each common area being visually, should really say common element, but they use, and we have this here, refers to the term common area, not common elements. I think what they meant is common elements because that's really what the portions of your building are. Common areas really is more of a defined term from the HOA Act. So when we say common area, I think what they meant to say is common elements. That could be part of any type of a cleanup bill. So, but again, need to inspect that and provide just like with any other reserve study, but now you're adding the structural components to it. So as we talked about before, the official records portions of 718 were amended. It requires the association to maintain structural integrity reserve studies for at least 15 years after the study is completed. And we noted here that the amendment was to the accounting records portion of the official record statute. So again, it kind of got thrown in there, maybe not might not be the most appropriate part, but I mean, that's where it was included. The association is required to maintain inspection reports described in 553-899 and 718-301, and any other inspection report relating to a structural or life safety inspection of the condominium property for at least 15 years after receipt of the report. It's also amended to provide that a renter of a unit has the right to inspect the inspection report. So there are limited records that are official records that renters have rights to. This would be one of them now that's added to it, that they have the right to inspect the inspection report. And that's, you don't have to provide it to them. You know, we talked before about the requirement to mail it out and to post it and to put it on the website. There's no requirement that you physically hand deliver it to the renter, but they have the right to inspect it if they request it. It does say that the inspection reports, let me see, and a copy of the most recent structural integrity reserve study available on its website, again, or through an application that can be downloaded on a mobile device. That was a recent change to the statute that you can have a mobile app to satisfy the website requirement. It applies to associations managing 150 units or more. Be interesting to see if this changes to the 150, that there's been discussion of making it applicable to all condominiums to have websites. But again, the website requirement's only for 150 units or more. All right, so the budget portion, 718-112-2 was amended regarding budgets. It provides that the amount to be reserved, which is the reserve item, is determined by the association's most recent structural integrity reserve study that must be completed by December 31st of 2024. If the amount to be reserved for an item is not in the association's initial or most recent structural integrity reserve study, or the association has not completed a structural integrity reserve study, the amount must be computed using a formula based on the estimated remaining useful life and the estimated replacement cost or deferred maintenance expense of the reserve item. Owner-controlled associations cannot waive or reduce reserves after December 31st, 2024 for items listed in paragraph G, which is under the structural integrity reserve study. The next part here, it prohibits developer-controlled associations from waiving or reducing the funding of the reserves, and it says any reserves is written. So that's a change, obviously, to the statute that prevents developers from reducing or funding of any reserves. The only thing for owner ones is, again, that you cannot vote to waive or reduce the structural integrity reserve items. And that's what we have on the final point here. As of December 31st of 2024, may not vote to use reserve funds or any interest accruing thereon that are reserved for items listed in paragraph G for any other purpose other than their intended purpose, which is the structural side. So what's interesting is this last bullet point is that you could argue, as written, that this applies to all condominiums and co-ops, whether or not you're 3 stories in height or higher. If you do have a structural integrity like reserve fund for any structural components, this doesn't say only for 3-story or higher condominiums or co-ops that you cannot use for other than their intended purpose. It just talks about the actual items. So if you happen to have those as a 2-story or less, for example, condominium or cooperative, the argument here is that now that you have those, you cannot vote to waive or reduce those, even though you're not a 3-story or higher condominium. They may amend that, and they may clarify to say that that only applies, but as of right now, it's kind of like if you are reserving for it, then you can't waive it going forward, even if you're not a 3-story or higher one. So that's something to be mindful of. I don't know that a lot of associations that we work with have had that issue, that they've actually been reserving for those. But if you have, it would appear that you would be locked into not being able to waive or reduce those, which ultimately is probably a good thing. I think from the standpoint of if you've already started waiving those, or I'm sorry, not waiving, but collecting those, continue collecting those to make sure that the money's available, make it less likely for a special assessment, or if you have to have a special assessment, that it's not as high. I think that whenever possible, you want to have fully funded reserves, of course. All right, so 718.112.2G was amended regarding structural integrity reserve studies. It kind of moves around certain subsections of the statutes, but it says that an association must have a structural integrity reserve study completed at least every 10 years after the condominium's creation for each building on the condominium property that is 3 stories or higher in height, and which includes at a minimum a study of the following items related to the structural integrity of the building. And this is, so I kind of gave a summary before, but this is what actually needs to be addressed. The roof, load-bearing walls or other primary structural members, the floor, the foundation, fireproofing and fire protection systems, plumbing, electrical systems, waterproofing and exterior painting, windows, and then any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000. And the failure to replace or maintain such item negatively affects the items listed in A through I, which are these other items I just mentioned, determined by the licensed engineer or architect performing the visual inspection. So this is a little bit of like a catch-all, is that subsection J there. And that needs to be included as part of this structural integrity reserve study that's going to be performed. Under 718.112.2G2, before, so if any of you are in here in a developer controlled association, or if you're an owner in a developer controlled one, says before the developer turns over control of an association to unit owners other than the developer must have a structural integrity reserve study completed for each building on the condominium property that is 3 stories or higher in height. So this is actually part of then the turnover requirements, is to have that initial structural integrity reserve study completed. Now, with anything, when the owners take control of the association through turnover, you'd obviously want to take a look at that, make sure that it was properly performed and everything else. Not saying, I'm not, it's just the owners are going to be living with that report going forward. The developer is doing that, of course, and many are good developers that will make sure that they are providing, and satisfying what's required by the statute. And they want to have a good product and a good building that's provided over to the members, but they're also still not the ones that are going to be living with the buildings going forward. So even if that is done, I would recommend having it looked at. If it's by somebody that you're not familiar with, or if you have any questions regarding it, I think it's always good practice to then double check with somebody that could otherwise perform that report to see if anything might be missing or if there may be any issues, just because, again, if that is performed, then it's only within 10 years is the next time that you have it. But you don't want to go 10 years down the road and realize that the one that's provided to you by the developer was missing some components or was wrong on the funding side or anything like that. So that's where I would just say it's good that there's a requirement for it, but I would still double check whatever the developer provides to you as part of the turnover. And then for 2G3, associations existing on or before July 1st of 2022, which are controlled by the owners other than the developer, must have that study completed by December 31st of 2024 for each building on the property that is 3 stories or higher in height. If an association fails to complete the study, the failure is a breach of an officer's or director's fiduciary relationship to the unit owners. That could give rise to liability for a claim made by any members that may be damaged. Certainly, it's why you have D&O insurance in place for any such claim, but the fact that there's a statutory provision that it seems pretty black and white that if it's not completed, that it could be a statutory defined breach of your fiduciary duty to the members. So that's why they're really just trying to show the importance of why this has to be performed and the potential liability there for directors that don't have it performed in time. All right, so then 718.112, it talks about and defines what the mandatory milestone inspections, refers back to 553.899. Says that if an association is required to have the milestone inspection performed, it must arrange for the inspection and is responsible for ensuring compliance with the requirements of 553.899. Association is responsible for the cost. If the officers or directors willfully and knowingly fail to have a milestone inspection performed, such failure is a breach. Okay, so willfully and knowingly, that's the key. And we had that, quote in here, we took that right out of what the statute provides. So I don't want to scare everyone here and thinking like, well, what if it's outside my control and we miss it? Am I going to be successfully sued personally? The answer is likely going to be no, if you can show that, look, we made arrangements for this to be done. The party that was performing it, backed out on us. We had to go find somebody else and they didn't have availability. If you can show that you made efforts for it, and maybe if something's provided a little bit afterwards, I don't think that there's going to be any type of successful claim. The biggest thing is just showing that you made efforts to do it, which is why I still think you should get going, sooner rather than later for it to not be going up against the time frame. But it's the willfully and knowingly fail. That would be the biggest thing. That would be more of a board saying, yeah, we know this is a requirement, but we haven't seen anything wrong with our buildings and we don't think we should undertake that expense. That would be a willful and knowing violation of the requirements in the statutes. So that's part A. Under B here, upon completion of the phase 1 or phase 2 milestone inspection and receipt of the summary of the inspection report from the architect or engineer, association must distribute a copy. We talked about this, to each owner, regardless of the findings, by mail or by electronic transmission, posted to the property and placed on the website if you're required to have the website. There's another change under this regarding 718.3014 regarding transition of control of the association for condominiums. It adds subsection P to provide that notwithstanding when the certificate of occupancy was issued or the height of the building, the developer must provide a milestone inspection report in compliance with 553.899, including the official records. So that again, that's added to the turnover requirements under the statute. And this again is what needs to be included as part of the inspection, which includes the following: the roof, the structure, fireproofing and fire protection systems, elevators, heating and cooling systems, plumbing, electrical systems, swimming pool or spa and equipment, any seawalls, pavement and parking areas, drainage systems, painting, irrigation systems, and waterproofing. 718.3014R was amended and added to require that the developer provide, after turnover, a copy of the association's most recent structural integrity reserve study. 718.501 was amended regarding the scope of the division's authority. The division was given authority to enforce and ensure compliance with complaints related to the procedural completion of the milestone inspections under 553.899. So we'll see what further comes out of this. Obviously, this is all pretty new. We don't even have up the reporting provisions yet, which is under the next part. that associations existing on or before July 1st of this year, which is just a couple of weeks ago, provided the division by January of 2023. Basically the information contained in here, which we talked about before, number of buildings that are 3 stories or more in height, the number of units in those buildings. So not for all of the condominium, just those buildings. So if you're in a condominium that doesn't have any buildings at 3 stories or more in height, it's going to be a pretty quick report. It does place an obligation for the division to compile a list of the number of buildings on condominium property that are 3 stories or higher in height, which is searchable by county, and must post the list on the division's website. So there'll be a public database of information that we can find this. Associations must provide an update in writing to the division if there are any changes to the information within 6 months after the change. Probably not going to apply to most people in here because you're already in established communities, but this could be where, communities that are under development or phase development that might add, buildings after the reporting requirement that are 3 stories or more in height, they would have an obligation to update that. That's really more probably on the developer side than anything. 718-503 was amended to require additional disclosures of condominium developers and non-developer owners incident to the sale of units. So under the developer disclosure requirement, it requires the developers to provide a copy of the inspector prepared summary of the milestone inspection and a copy of the association's most recent structural integrity reserve study or statement that the association has not completed it to prospective purchasers. So again, this is part of the disclosure requirement to prospective purchasers. And it provides for the right of voidability if not provided. The non-developer disclosure requires a non-developer unit owners to provide a copy of the inspector prepared summary of the milestone inspection report and a copy of the association's most recent structural integrity reserve study or statement that the association has not completed a structural integrity reserve study to prospective purchasers. So again, more information provided in the sale of units to let future purchasers know of the integrity reserve study and any type of milestone report, so they know exactly what they're getting into with the buildings. 718-504 was amended to require additional documents to be included as exhibits to the prospectus and offering circular for residential condominiums of more than 20 units. This is more for newer stuff, probably not applicable to most in here, but it is part of the legislative change. It requires a copy of the association's most recent structural integrity reserve study or that they haven't completed it, and the milestone inspection. So again, disclosure, providing that as part of the initial creation of the condominium, as part of the purchase for units, whether it's from the developer or the non-developers, so that people know what they're getting into with the buildings. So part of our conclusion on this, I know we have some questions here. I'm happy to take questions. And again, I apologize for getting in late with some of the tech issues on my side here, and that's on my fault. I apologize again for that. But this, I know that this was, if you're in an HOA, for example, if you attended this, I appreciate you attending it. I think that, whether or not this could be a requirement for HOA structures in the future, it's possible. I think that this is largely focused though on the 3-story or higher, of course, requirement, and may be expanded to all condominiums. I'm not sure if that's going to be the case. I think that they needed to have some type of a cutoff there for, what's reasonable, what can we at least introduce initially, and looking at, again, what are the buildings at most risk, and that would be the 3-story or higher ones, right, from a structural component standpoint. But condominiums and cooperatives are encouraged to contact their legal counsel to discuss how they may affect them in terms of getting going on these reports, getting them arranged. With our firm, we've worked with a number of licensed architects and engineers. Talk with your attorney, likely can provide recommendations, or at least it's tough to provide, and I say recommendation very loosely. I can say that we have worked with them before and we know that they're licensed for it. We're always hesitant, even as attorneys, because it's tough. A recommendation and advice is a tough thing to provide too, and especially for something like this where there's such so much at stake with it. But I say all that to say that we work with a lot of good engineers and architects that we can recommend, and I think you're going to find though that you're going to find a lot more coming in. The joke was that this is the Engineer Employment Act. And I use that lightly, but really it is a necessary thing. I think it was a good step for placing more requirements for inspection of buildings. I think there's going to be a lot of change that comes out of it, whether it's through future legislative sessions and how this is all implemented. Many questions do remain though regarding how parts of the law may be interpreted prospectively. we provide this to say that this is what's required so far, but we're all kind of learning as we go along with this, honestly. It's only been in place for a couple of months now. The only thing that I kind of want to end with before I go into questions is, there was a lot of talk about Surfside and what we could see happening in the legislative sessions, what we think should happen. And I think that the hard part that some communities are going to find is that, okay, there's a requirement to have a milestone inspection report done, right? And then that might require then a phase 2 report, and if there's a phase 2 report, that means that there likely is going to be work that's going to need to be done that the association is going to have to pay for. So let's say you identify all of that, you have the reserve study done, and there's items identified in there that you need to reserve for. But what happens if it comes out and says, hey, this building needs substantial structural repairs that are going to cost millions of dollars? And let's say you're in a condominium that maybe your unit sells for $350,000, $400,000, but that you effectively need to collect $50,000 or $100,000 from each unit owner. I can't remember what the number was for Champlain Towers and Surfside, but I believe, if I remember right, I thought it was going to be closer to $100,000, even if the owners had been specially assessed to perform the work that would have maybe addressed some of the structural concerns. And that's just a practical, almost impossibility for so many owners in the state. And so this is more of like a big picture, almost philosophical discussion and thought that I've had, that I think is a good step, again, to identify, to make sure that associations are looking for it and that there's a process in place for collecting for it. But there's going to be a practical difficulty with some communities with this. And I think what we'll find, and there's been discussion, which is an alternative form of getting rid of the condominium that you live in. And a brief primer on this, the way that you get rid of a condominium, it's not just as easy as bulldozing it and putting a new type of development up and people being bought out. I mean, that can be part of it, but really a condominium is a legal form of ownership. It's a unique form of ownership, right? Where you own the spaces of your unit in as defined in your documents, but that there's common elements that everybody has a common interest in. In order to get rid of that, you have to do what's called termination of the condominium. There's 2 ways that you can terminate a condominium right now, and they have different thresholds depending on which type of termination. There's an optional termination, which is more commonly associated with maybe conversions. If an investor comes in, buys up the units, and then terminates the condominium to turn it into an apartment complex or some type of a rental complex or maybe a hotel. That's more difficult to do in terms of the vote that's required from owners, because you're effectively forcing somebody to get rid of their residential unit, their residence, their homestead potentially. So there's a voting provision for that, and can be defeated if a certain small percentage of owners vote against the termination. So that's the optional side. Kind of difficult to complete. Usually you only see that when the entity knows that they have already the appropriate number of units to control it. But that's not really what we're talking about here. That's more, I would say, more of a financial decision to get rid of the condominium form and convert it more to an apartment or something like that. That can go into play for what I'm going to talk about. The second one, though, is if there is any type of an insurable event. An insurable event, like let's say a hurricane comes through, destroys the building, and there are insurance proceeds, but there's a discussion of, this is how much we got, this is how much it's going to cost to rebuild this. Do we want to actually move forward with it, or would we rather terminate the condominium, have a plan for that, to be able to sell off the property and have all the owners receive their portion of the insurance proceeds, but then terminate the condominium afterwards? That is easier to do. There's a lower voting threshold associated with terminating the condominium due to something resulting from an insurable event. Okay, so that's the second part. I think that there probably needs to be some type of discussion for the ability to terminate the condominium based upon anything to do with the structural integrity reserve study or the milestone inspections, that makes it almost a practical impossibility to fund the structural repairs that would be needed in order to satisfy the requirements of the statute. So in other words, it's too expensive for us to maintain this building and to do the work that needs to be done. So there should be a little bit easier way of terminating the condominium than the optional one, which isn't related to the structural side, and it's more related to a financial decision that's made by investors that may want to buy them up and, again, convert them into apartments or hotels or something like that. So I know there was discussion regarding that. I expect that to be a discussion topic going forward, because, again, like we've talked about big picture wise, we've addressed some of the issues, which is mandatory inspections, mandatory reserve studies, can't waive those amounts, but you still have to have the ability to collect those amounts. And if you can't do that, depending on the ownership type, the age of the building, the demographic, and everything else like that, I think there's going to be discussion regarding being able to keep the condominium going forward. The other thing is, probably as you can tell from all this, and one thing that I always talk about when I teach a board certification class, which is they've defined certain things that could give rise to liability for directors and officers. Make sure that you have good D&O policy in place. If you are volunteering for your board, that you're properly protected. Talk with your insurance agent, have them take a look at your existing D&O policy, especially in light of the changes here and what the requirements are. You know, me serving on a board as a volunteer, the number one thing I would want to make sure is I want to make sure we have a good policy in place that protects me for my decision-making. And you're going to be protected as long as you act reasonably. And we have a lot here in the statute that was amended that can provide direction, that can help you act, you know, in accordance with the statutes. But again, even if you're satisfied, even if you can't be successfully sued, it doesn't mean that you're going to be prevented from being sued. Unfortunately, as a member, if somebody feels like they have a cause of action. So again, I always distinguish between, can I be sued for something? Yes, of course, anybody can be sued for anything, but whether I can be successfully sued is another thing. But you want to make sure you have proper insurance in place to defend you so that you're not paying out of pocket. The association's not paying out of pocket for defense costs for something that should be covered by your insurance policy. So I bring all that up too, because with all this being added on, there's additional potential liability. I mean, engineers and architects are looking at it, CAMs are looking at it. Us as attorneys, we're looking at it too. There was litigation initiated against a law firm that represented Surfside. I'm not going to get into my opinion on the merits of that case, except to say that the law firm was sued as well. So there's everybody else that's connected with this has some concerns, and we want to make sure that you're properly protected. And this is mostly to the directors and officers on this call, to make sure that you're properly protected there, that you're not paying out of pocket for something that you're volunteering your time for. So that's what I have for the presentation. And again, I'm going to make sure that this is provided to Vesta so that this can be emailed out to everybody. I'm going to go through the Q&A side to make sure that I can answer any questions. Harvey asks, are 2-story buildings required to do a reserve study like the 3-story? No, that's only a requirement for 3 stories in height or higher. Now, can you choose to do that? Certainly. There's nothing preventing you, but it's not a requirement to do so. Jeff says, does a condo with 150 separate units not over 2 stories high require to comply with this new law? No. So you still have a mandatory reserve requirements that have already been in place, have always been in place, you know, for the roofs, the painting, the paving, and anything over 10,000. But if you're not over 2 stories in heights, or if you're 2 stories or less, then you don't have to have the reserve study has the visual inspection with the architect or engineer. You would still have your normal reserve study done. I think I see a lot of questions here regarding the 2 stories. So no, 2 stories are not needed to have the milestone inspection and the special reserve study conducted. Albert asked, which parts of this apply to 2-story buildings? The only thing where I saw that they didn't, distinguish it is that one section that says that if you do have reserve items that are under paragraph G, which identify the structural items, that if you do fund those, then you cannot waive or reduce those going forward. So so if you do happen to have those now, they may amend that later on to state that for any 3-story or higher condominium that has reserve for these, they cannot be waived. Then that would only then apply to the 3-story or higher. But if you are a 2-story right now and you have reserve items for structural components as defined under G, I would read that to say that you can't waive or reduce those even if you had a member vote. I think there was one question just about reserve funds in general. I think, as I understand this from Christine, saying, do 2 stories also have to have fully funded reserves? Yes, this doesn't change the requirement for 2 stories to have fully funded reserves for the study that you have to have done. This just adds additional reserve study requirement and places restrictions on the ability to waive or reduce those for 3-story or higher ones. Nancy says, we recently had a reserve study. Will this suffice in total or partially for the milestone or the structural integrity reserve study, both of which we're required to have? Nancy, that's a great question. What I would say is you need to get with a reserve analyst to look at what was performed before the statute came into play, and then look at the additional requirements for the structural component side. And I would say that you need to have a supplemental reserve study done that matches the requirement, because you would want to have that engineer or architect, you have to have them perform the visual inspection side, that couldn't have been done by your reserve analyst. So you're likely going to need to have an addendum or update to it, maybe not a brand new one for everything. You might be able to just have it for the new structural components, but it's almost positive that you're going to have that done. And in fact, I would recommend that you have that done by December 31st of 2024, because it's going to have items that weren't required to be included. And unless you had, I guess the only way I could see it is if you had an engineer or architect perform the visual inspection and you otherwise satisfied it, even if it was before the statute came out, which I doubt was the case, nor should it have been the case, because we didn't know that this was going to be a requirement. There was a question, I think I addressed this at the end. These requirements are going to bankrupt a lot of associations. I talked about the practical realities of it. I completely understand. I think that's going to be, there's always discussion of, right, it's great that you can require this, but there's still the practical reality of funding this stuff. And I think we're going to see how that's going to play out. The question was, does the new law disallow pooled reserves? I don't know that I would say that it disallows pooled reserves. I would say, though, that you need to make sure that if you do have pooled reserves, that you always have enough in place that would cover the full funding of the structural components that are needed. It is a good question, though, on pooled reserves as to how that's being done. But, even right now, though, you can have pooled reserves. Let's say you're a two-story condominium. Let's put aside everything with the structural side. You can have pooled reserves, and you still have to have fully funded reserve items, and you can only do less than fully funded or pull for anything else unless you have a member vote. So I think we should still be able to have the pool reserve side, but we're going to want to have more strict compliance with it, especially make sure that you're not in any way below the amount that's needed for the structural components, so that when the time comes to have those, that you have the money in place. Teresa said, a three-story building, does the garage count as the first floor if the living areas start from above the garage, which has 2 levels above? It's a great question. I believe that this might be open for discussion still, but we've been interpreting this to include the garage as part of the story. So you have a garage and then 2 stories above that would be a 3-story structure that's included. Let's see, Teresa said, your example you just mentioned, would the assessment partially be paid by the buyer? I think if that's a question of like a special assessment, if there's a new owner, certainly, just like with any other type of special assessment, that if there is something that's passed or if the assessments go up as part of the reserve study, that any new owner would be responsible for it. Now, a lot of times, that can be arranged if there's a special assessment, if there's installments that are due, that's usually arranged through the closing, whether or not the seller pays for it or if the buyer understands that they're responsible for the remaining installment amounts. So that would largely be subject to the negotiation. But if it's not negotiated and it's left out, we typically include then on the estoppel, if it comes through our office, but really through management too, we'll include the remaining installment amounts that have to be paid on the special assessment that the new buyer will be responsible for. Teresa asked, do we have a class for condo conversions? I don't have that. And it's interesting, there was a lot of condo conversions, I would say probably in the 06, 07 time period. I think there was a lot of demand. I've seen, our main office is up in Northeast Florida. We have seen very few condominiums being built up here, let alone then ones that can convert. So be interesting to see, but we're always happy to discuss. I'm happy to discuss with Vesta any type of classes that we can offer that would be helpful. Doug says, if the reserve study is completed in 2022 or 23, can full funding be phased in to full funding by the end of 2024? So I think that's saying if the deadline to have the reserve study done is by the end of 2024, but if you have it, can you phase in? My answer would be that if you have that reserve study, the structural integrity reserve study, and that identifies full funding, that once you have that, you need to have full funding going forward. You can't phase it in to have it begin at the end of 2024. I think it's a good question. I think I have to look at that further to see and look at very specifically, but I would say my initial reaction would be, once you get that reserve funding done and that provides for the funding amounts, that you should have the fully funded amounts going forward. I did not see any exception in the statute that says that you could only have that you had to have the full funding, starting in 2025 going forward. It did say something about not being able to waive or reduce them after that date. So I guess that could be the argument, maybe what you're referencing, Doug. But again, I think it's better get started if you're going to have the study done. Obviously, you're going to be a year or two ahead. It's always going to be the same end date, right? Whatever the remaining useful life is. So if you get it done, the study done a year or two before then your fully funded reserves at least are going to be less than if you had waited to have the report done right at the deadline. So when in doubt, go fully funded would be my answer. Julian said, are accessory buildings included, like one-story rec buildings, swimming pools, or maintenance buildings? So only applies to the 3-story or higher buildings. That would be included as part of the structural components that have to be included for your inspection report and the milestone, in the reserve study. Steve says, what applies to buildings less than 3 stories? It's the existing statute that provides, which is more generic in terms of the mandatory reserves that you have to have as a condominium, which is your roof, pavement, painting, and anything over $10,000. That's still applicable and has always been the case for condominiums of 2 stories or less. Elliot says, if after we have the milestone inspection and structural integrity reserve study done, and then a cleanup bill is passed requiring additional studies, then do we have to redo the studies? So let's see. Well, I think that's going to be prescribed as part of any type of cleanup bill, or if there's anything that was missed, they'll likely provide some time period like, hey, if you comply with the previous version of the statute, they very well may include that you don't have to have an updated one done for X number of years. But certainly that could be something where if they felt like they should have included something, and if you've already relied upon the previous language, my guess is that they will allow you additional time to provide it, but it's subject to what the legislature provide. And I think it's important to reach out if you see that coming down and you say, we performed the study and now you're adding additional items, reach out to your legislator, let them know, because that's very important. Them hearing from you as constituents is so much more important than them hearing from lobbyists. And the lobbyists will say that themselves. So if that is coming out, don't hesitate to reach out to them. But I also expect that they would provide some type of additional time period if you did comply with the newest reserve study that's required or inspection report. This talks about what about mixed use structures like condo hotels. I think that's going to be determined about how you're defined under the Condominium Act, but it's pretty basically for any 3-story or higher structure that's under 718 or 719. If you have a question though about it, please reach out to your legal counsel. I would have to take a look at your, if it were me, I would have to take a look at your governing documents and understand a little bit more. But in terms of if it's still a condominium, even if you have a rental structure as part of it, if it's 3 stories or higher, it's going to be subject to the statute. Lynn says that my 3-story building is part of a larger condominium with 2- and 3-story buildings. Are the condo officers, let me see, not our building president, on the hook for our compliance? What is the liability of our building president in relation to this law? I guess I'm trying to understand maybe a building president versus the officers. This says any directors or officers of the corporation. So I guess that's what I have to point back to, is that those are the individuals, the directors and officers of the actual corporation, which is the association, have that obligation. And then if you're a licensed manager, you're also required to make sure that your associations that you manage comply with this too. So there's liability for both the managers and the directors and officers on this. Fred says, do 3-story buildings 5 miles from the coastline need a reserve study done? Yes, it's just that the only thing with the miles from the coastline, that just talks about the milestone inspection report, if it's 25 years from the certificate of occupancy or if it's 30 years. That's the only distinguishing thing that you have to worry about for the coastline, is for that milestone inspection report. So if you're within 3 years or 3 miles, it's within 25 years of the certificate of occupancy. If you're outside of 3 miles, then it's 30 years from the certificate of occupancy that milestone inspection report has to be done. Thomas says, is there a state definition of any person qualified to perform such reserve study? It's a good question. Let me take a look. I know that reserve analysts, that there's a licensure issue there, and that if you go through certain groups like CAI, for example, which I'm a member of, I know Vesta is a member of, which is Community Association Institute. They have designations for their reserve analysts. But I'm not aware of the actual statutory provision for reserve analysts. If you have a question on that, certainly reach out with your legal counsel to make sure that who you're hiring, if you do have a question about it, or just ask them and say, hey, are you qualified under this provision of the statute? If so, can you just provide me with proof of that? And I think they should be able to easily provide that to you. Teresa said, what is the percentage you will consider as full refunding using pooled reserve? That's not for me to determine. That would be something you have to work with your reserve analyst on. If you've got pooled reserves with structural components that they will provide for you, and there's a statutory provision in terms of what fully funded is, but all the reserve analysts will know, and working with the architect and engineers as part of these studies, that they have to have numbers that are fully funded reserve studies. Because again, we're talking about liability. There's potential liability in the reserve analyst side here too. If they're taking what the engineer provides, and if they don't provide good information for the association to rely upon for how much should be collected and everything, and if there's an issue there, that could give rise to liability from the reserve analyst too. So everybody is making sure that they need to be on their game for this. I think I answered this one, Fred. Let me see. Joyce says, if we have no reserves, we have a year before voting no reserves. That would be correct. Like if you haven't been collecting reserves, and now the thing I should clarify though is that by law, every year you have to have fully funded reserves. The only way to have less than fully funded reserves is to have a vote of the membership at a meeting where a majority, you have to make quorum, and then a majority of those members vote to waive or reduce the reserves for that year. And that needs to be done each year. So yes, by law, you can continue doing that for any of your reserve components. But once you have this mandatory reserve study done for the structural components, if you are a 3-story or higher one, then you have to fully fund those structural components. Even if you have a vote to waive or reduce reserves, it would only apply to the non-structural components. You would still have to have fully funded reserves for the structural components included as part of the reserve study. Chris says, will a 3-story condo in the St. Johns River need to comply? Yeah, the only thing, like the coastline thing, is just for the milestone inspection, which is if you have to do it within 25 years or 30 years. That's the only thing you have to worry about for the water line. Anything else, if you're 3 stories though, all of this applies. It's just the milestone inspection of the timing for that. Steve says, do 2-story buildings need a reserve study? Yes. Look at the statute. There's mandatory reserve requirements there. It's just that you don't have the same structural components like you do if you're in a 3-story or higher. Teresa says, how do you consider the community needs to follow the milestone requirement if some buildings are at the coastline, so some are much behind the coastline? Should only those buildings be inspected differently under the reserve study and milestone? So I guess if I'm understanding you correctly, if you're in a condominium and maybe some of them are within the 3 miles and some of them are outside, that's just going to affect the time period, again, the 25 or the 30-year requirement. If you're already if let's say some of them are within the 3 miles, just have all of the buildings inspected at the same time. That would be my recommendation. I would imagine that might add some expense initially, but it's probably gonna be better than having a reserve study or an inspection report done for some buildings and then having to come back again 5 years later for the other buildings. Steven says, what's the estimate for a reserve? Great question. I'm not sure, especially what reserve analysts are charging for this new one that adds the engineer components with it. So again, why I'm recommending everybody, if you're going to be required to have this done, that you act on it, quickly now, because as you get closer, people are going to get busier and you're going to run at risk of not having it done on time. So I would reach out to them and get quotes for that right now to start arranging for it. Adam says, do you see an opportunity for a public adjusters to handle any of these future inspections to take the workload off of engineers and architects, or opportunities to assist communities that are in good condition? Great. That's a great question. I think though, unless they amend it, you're still going to need to have engineers and architects as licensed entities as provided in the statute, that they're going to need to be involved for the visual side of this. Maybe they amend that later. Maybe you see public adjusters, there's so much that there's some overlap on a lot of this stuff. When I think of public adjusters, reserve analysts, that they perform a lot of functions that sometimes overlaps, even though they'll say, hey, I'm not an engineer and architect. There's similar functions. And I'm sure if you are one, Adam, or if there are any on here, you probably are nodding your heads at that, right? But you have to watch what line you can cross, of course. But as of right now, I think that the idea is to have the licensed engineers or architects that are most qualified, at least that the legislature sees as most qualified, to handle this visual side, to make sure that they are then providing the appropriate reports and recommendations that can then be priced out for the reserve side, how much should be, collected, and what work that needs to be done. All right. Well, thank you all very much. Again, sorry for the brief delay getting started here. I'll provide a copy of this update memo for everybody if they'd like to have it. It has all the statutory references. And again, thank you again for Vesta for putting this on. I know that this was kind of more specialized as to the 3-story and higher condominiums, but great refresher. I think there's some good questions here for condominiums of 2 stories or less, just for what is already still required for you. So again, thank you all for attending.